Hey, Matt Barton, hit your button. I'm gonna call on you to pray, whether you know it or not. All right, Representative Barton.
Do the prayer. Please bow your head. Heavenly Father, thank you for letting us get together today so that we can make decisions for the state of Georgia. Lead us in the right direction that we can better serve you. Thank you very much. Amen.
Thank you. We've got 4 bills on the agenda. The first one is going to be House Bill 1409. I'm going to let Vice Chair serve as chair. Do I have that? Do I have 1409 in front of me?
I should say.
Okay, all right.
I'm just going to do whatever Casey does. Here, watch this.
All right, Mr. Chairman, we're going to call House Bill 1409 LC 365168. And you go ahead and present your bill.
All right, thank you. This is a bill, an agency bill coming through the State Workers' Comp Board. It's a bill that we do periodically. I don't think we did it last year, but we did it the year before. It simply raises the weekly wage, maximum wage for workers' comp by $50. I will tell you as chairman, a lot of things that you don't see behind the scenes. I get a lot of people coming to me. I've got people who would like to see it 0. I've got people who would like to see it to be 100, but this is a recommendation from the State Workers' Comp Board, and it's the original version, and would like to see us move this out.
Thank you. Well, we now got questions lighting up. Number 2, that's Representative McLean.
Thank you, Mr. Chairman. And thank you too, Mr. Chairman, for the bill. I guess the only question I would have is what was so that was the advisory board recommendation of 50, or was it 100, or was it increments? I'm just, because I'm kind of like you, I get a lot of them and I want to make sure I get it out. What was said, or either what was said to you or what was said to me, Mr. Chairman.
Yeah, so this is the original bill. They meet annually and then additionally as needed. And this is one of the subgroups from the advisory council that then reports back to the State Workers' Comp Board. And this is their recommendation. All the other suggestions are groups who would like to see lesser or greater amounts, but this is the recommendation from the council and then from the State Workers' Comp Board.
Thank you.
Number 14, is that you representing Kennard?
Yes. Thank you, Mr. Chair. and Thank you for the bill, Chairman Werkheiser. It's my understanding that there was an agreement among the council of $100 that would be brokered, 50 now, 50 later.
Well, again, there's a lot of discussion, what different groups want. I'm not sure it was brokered. There's a commitment, then there is some discussion about whether this body could further, I think the word, commit a future legislative body. But again, there's a lot of discussions about what the amount should or shouldn't be.
Further questions?
Sure. Oh,
Go ahead.
I would like to, at an appropriate time, make an amendment that we sanction the $50 now and then $50 more in 12 months.
Well, right now, that would not be the time to do that, but we'll see if there's time for that later. Thank you. Number 17.
Hey, that's my old football number. Thanks, there, Chairman. I just want to thank you for bringing it. And obviously, we're committed to the advisory council and the work that they've done and all the vested interests that are input on that advisory council. And this committee is committed to, working through that process, and it's allowed us to have one of the best worker comp situations in the nation. So when appropriate time, I have a motion.
All right, no more questions from the committee. We've got 1, 2, 3, 4, 5, 6, 7 people signed up to. Oh, Representative Parks online with the questions. I'm sorry. Go ahead. We need to get him.
Thank you, sir. Can you hear me?
Yes.
Chairman Werkheiser, one question I had, because I had also heard that there was, or that the advisory committee had recommended $100, not $50, and I think we would be supportive of Representative Kinnert's amendment. But a question I did have was, how many states index workers' comp so that there does not have to be this kind of manual increase? I'd be curious whether or not Georgia is in the minority or majority of states that actually index this, so that this doesn't have to continue to be kind of a legislative back and forth, so to speak. Would you be able to speak on that?
Yeah, I've seen some reports that I'm sure you have too, and I think somebody's going to speak to that. We are one of the few states that do not have an automatic index.
Thank you, Chairman.
Is that all for online? All right. Start with Jonathan Smith. Signed up to speak to the bill. Jonathan in here? Nope. Oh, no, he's on Zoom. Okay, sorry about that. Jonathan, you need to unmute if you're still online. All right, we'll go on to also online, Ray Kalfani. I hope I got your name close to right.
Yes, thank you. Thank you, Chairman. I'm actually here to testify on another, so I'll yield back until we get to that time.
Okay. All right, thank you. Well, David needs to write better.
I wrote that's on 1375.
1375, all right. What else we got? Josh,
I don't have any comments at this time.
no comments. All right, so that's it for the comments on this bill, Mr. Chairman. Now, I do have one question for you. As I understand, I know how, we all know how these things work. The final version out of the advisory council was to do this. And
That
that's,
is
even though they
correct.
talked about other things and different ways to go. So what is the will of the committee?
Move to pass.
We got a motion to pass. We got a motion and second. Any discussion on the motion? Representative Kennard.
Yes, thank you, Mr. Chair. I'd like to make an amendment to affect the $50 as is in the bill currently, but then to add another $50 in 12 months, so that in 12 months, we'd have a total of 100.
So you're making a motion to amend to something that we may or may not be able to do that could be changed between now and then?
Yes.
As the chair,
second it.
I'm going to suggest that we not take that amendment at this time and we look at it later. For several reasons. Number one, I think we've always had such a great relationship with the advisory council and we're trying to stay with their recommendations. And I know there's some other things already people talking about, we've already mentioned here today, that I think we might want to look at down the road and instead of locking us into something. So at this time, I want to rule that amendment out of order and ask for any further discussion on the motion to pass.
My hand is raised.
Thank you, Mr. Chairman. I guess my only concern is there anyone from the advisory, council that would like to just speak on this? Because I think it would help me a little bit if someone would, because I got roughly 15 phone calls from A to B and Z to zero, and I just want to hear from them if I could. Anybody?
Absolutely. Mr. Potter is volunteering his gracious time to share with us and podium mic. There you go.
Mr. Chairman, members of the committee, thank you. My name is Bobby Potter, and I chair the advisory council for this past year and for many years have chaired the legislative committee of the advisory committee. I told the chairman in advance, I had no real desire to be in front of this microphone today, but I do want to clarify a few things. So the commitment from the advisory council has been to stay as close as we can to 2/3 of the statewide average weekly wage as the maximum rate. That has changed from time to time. Sometimes it's every 2 years, it may be 3 years. Sometimes something like COVID intervenes. That's the overall commitment. In the advisory council this past year, we looked at the pure math, and the pure math is we're just short of $100 behind. So that was a thought. But what I personally indicated in the legislative committee at the meeting in October and then thereafter, and in front of the big group, was, having lived in this life for many years at the Capitol, sometimes things are just politically unachievable in 1 year. I thought the $100 might be too big of a bite. I've lived through it when a former governor wanted to veto a bill that was otherwise good because the number was too big for business and small business. It was for that reason and some other reasons we felt like it may be $50. And then the term has been used throughout these discussions, well, 50 and 50. Well, and Representative Kennard has raised a potential amendment which would reflect some of those conversations that occurred in the hall and beyond in the hall and other telephone conversations. I would tell you this, the advisory council commitment was at the $100 level over time. I have used the phrase 50 and 50. However, I would tell you that what we do is recommend to the state agency. And I've had many conversations on this particular bill with the chairman of the state agency. And he gets calls just like you do, Representative McLean, and you do, Representative Kennard and Representative Park. He gets it out of both, in both ears. And I do too, on both sides. After all of that, I would suggest to you the best course of action. This is me, this is not through the advisory council, because we didn't meet in the last few days, but that the bill is presented at $50 from Chairman Werkheiser would be the best course of action for this group and for this legislature this year. I am concerned that if there's an amendment, if it is 50 and tries to bind the state legislature for 50 next year, that the bill will run into problems. And I'm concerned about that. And I don't want to voice where those problems would come from, but I can tell you that Chairman Benson has had conversations with all stakeholders and gets some of the same stuff that you all get, but get it from the same side as well. And he's navigating the governor's office. And in this particular year, it is about as political as any that I've seen in the last 40 years here. So for many of those reasons, some of that is amorphous and not very direct, but I would ask that you pass the bill as is. And there's other conversations about indexing and other reasons for that, but this system has a fairly delicate balance. And if it gets out of kilter on one side, there's going to be a group on another side, whether it's this year or next year, that comes back with something sometimes that I perceive as draconian. And it would be sometimes, because I've been in the defense lawyer side, sometimes it'll be from my side, but I still perceive it as draconian and would not want it to pass and resist that. So we're trying to maintain the balance. I hope that is responsive to the question, because I did want to make it clear where the advisory council is on, and hope I have, and that was the recommendation to the state board, the agency itself, and then they've got to navigate the rest of that to get it to the point where it is right now.
All right, thank you, Mr. Potter. If I could, one thing, and I appreciate your words and I understand exactly where you're coming from and makes sense. On behalf of the committee, and I may be speaking out of turn, I would certainly like the advisory council to do a study and share it with the committee as soon as possible on indexing, what states do it, what it would look like, and whether or not that would be beneficial for the state of Georgia to make that change. Is that acceptable with you, Representative Kennard, also addressing your concerns? Or that was Park, excuse me, Representative Park online was the indexing. So
We can do that.
I appreciate it.
Yes,
Thanks.
sir.
Representative McLean, you got a question?
Well, I guess I want to say thank you, Ms. Potter, for bringing that, because I wanted to hear from, the group that said it, because I do believe that. I guess my only other question is to Representative Kenner is that is there a problem with the 50 now and the 50 the next year? Lead council, is that a problem? I mean, I
I
don't
think I
know.
can answer that.
Okay,
It's-
I'm sorry, I didn't.
No, I think it's just restating what he just said, is we could do anything.
Right.
But this is an agency bill, and this is what they've recommended. And again, it's been said several times, they hear it from both sides. If we try to do something else, this bill could run into problems and the 50 would disappear. And I don't want to jeopardize that. And so I think we need to stick with the agency bill. We do not have a track record of taking their recommendations and changing them. And so my recommendation of this committee is to take this bill and pass it on, and let's move it out.
All right. We still have Representative Casey's motion on the floor of due pass and seconded. Is there any more discussion on that motion? Seeing none, all in favor of passing House Bill 1409 LC 365168, say aye. Aye. Opposed? All right, motion passes. You're on the
Thank
big
you.
rules.
Thank you, committee. Thank you, Mr. Kirby. Due to the amount of discussion, so that we can move as quickly as possible, so you'll know the order of the agenda. We're going to do Senator Albert's bill next, and then Meeks, and then Representative Moore, and we should easily be able to get them all in. Senator Albert suggested we do the entire meeting in alphabetical order, and we can start that now.
Well said, Mr. Chairman. Thank you. Thank you for the opportunity to present this to you and your committee. We should be operating off of LC 365105S. This is a very simple but impactful bill. It's called the Protecting Georgia Businesses and Workers Act. Just to give you an idea of the broad support we have for this bill, it is supported by our friends at the Georgia and the Metro Atlanta Chambers of Commerce, our Georgia and American Hotel and Lodging Association, our good friends at the NFIB. We've got the Georgia Restaurant Association and numerous other folks that are here in support of this bill today. This is a very simple bill, as it makes sure that we all stay in our lanes and our different levels of government. We have seen in different parts of the United States, and what usually starts up in the Northeast or the West Coast or other places tends to creep down to other parts of the country, where local cities and counties are implementing labor laws impacting the hours that people could work. Let me give you an example. There are certain municipalities in the country today that are saying if a person who cleans a hotel room cleans more than 3,500 square feet, he or she then would have to get double time for any more work after that. Now, it doesn't matter whether that took that person 2 hours or 10 hours. Well, certainly that doesn't make good sense. This also has been examples of folks who are coders, who if they code a certain amount of lines a day, that then all of a sudden they would be moving into a scenario where they'd be paid either double or even triple time. Again, not accounting for the number of hours, which doesn't make any sense. So this bill also was worked with our friends at both the GMA and ACCG. I'm glad to say that we made some changes and worked together in that, so they would be comfortable with this bill as well. So very simply, the meat of the bill starts in section 2. It just says that no local government can adopt, maintain, or enforce charter ordinance, regulation, or rule or resolution the hours and scheduling time of an employer to provide employees. It does not in any way impact a local government from entering into a contract. That would be specific contractual terms between those. We all know that Georgia is a number one place to do business for 8 years, and we want to stay that way. And I think by virtue of the enormous amount of support we have from our business community, those men and women who are making sure that we keep everybody employed, this is I believe, a very good bill for Georgia. It'll keep us on top. If there are any questions, Mr. Chairman, I would yield.
Actually, I don't see any in person. There's one online. Representative Park.
Thank you, Chairman Werkheiser. Senator Albers, has there been any?
Hey, I'm gonna interrupt you. Help a little bit closer to your mic. We can hear you, but barely.
Hear me now?
Yes.
Okay, Chairman Albers, can you cite any instances of any Georgia municipalities who have enacted a local ordinance that would regulate output of employees? Or is this more based on concern from what out-of-state cities or municipalities have done?
Yeah, it's a little difficult to hear you, but I think.
Apologies.
I think you were looking for an example. I'll just give you one right off the top of my head here. Again, as I told you, this is starting in the Northeast and the West Coast, and they typically migrate to us. Just in the city of West Hollywood, as an example, if someone cleans more than 3,500 square feet of a hotel room, they have to be paid double time. Now, just to put that in context, some of the large suites in a hotel now are 3,500 square feet, which means they clean one room and they are done for the entire day, or they get paid double time for perhaps the next 6 to 7 hours of the day. That just doesn't make sense. We have lanes in government for a reason, right? We have a federal government, a state, a school, a county, and a city. And that is just not the role of those governments. It is the role of both the state and the federal government to regulate those things. We want to make sure everybody stays in their lane. Thank you.
Thank you, Senator Albers. If I could just clarify, I think I was trying to ask if there are any Georgia-specific instances of any Georgia municipalities who have enacted a local ordinance that regulates output of employees.
We have heard of some folks who are exploring it. I'm not aware of one put into place, but in an effort to continue to stay the number one place to do business, and knowing that those things that start in those areas tend to creep into Georgia, we want to make sure that we are protected. And we're also sending a strong signal to those that want to move their business here, expand their business here, and to our small business owners, which are really our lifeblood of Georgia, that we're going to stay ahead of this.
Thank you.
Thank you very much. It's more of a comment than a question, but I think in response to Representative Park's question, I think it's important to get out in front of things, because I think sometimes we local folks get together on a national level and they come up with ideas together, they brainstorm, and they bring some of the bad ones back to Georgia. And so getting out in front and shutting that door on the front side is super important, I think, and I appreciate you bringing the legislation, and I'll be ready to make a motion whenever it's appropriate.
Thank you.
I think we have one more question, then we'll take that motion. Representative Kirby.
Thank you, Mr. Chairman. Thank you, Senator, for this bill. I just want to make sure and settle make sure nobody had any heartburn. A company like mine that has a base rate and incentive pay for incentive workers in like a manufacturing plant, the more they make, the more money they make. This doesn't affect that, and workers in those type of industries can go at it and make all they can, right?
Absolutely. And thank you for your capitalistic approach.
Thank you.
So my hand-
Representative Doreen Carter online.
Okay, great. Thank you. I appreciate that. Senator Albers, a couple questions. I think I heard you say the town where you've seen this was Hollywood. So was that California or Florida?
That was West Hollywood, California, although there are many other examples. That's just the one that I have in front of me at this moment.
No, I just wanted to be clear, because my thought here is I was wondering what is the minimum wage there, and if this is not happening in Georgia, and some of these proactive bills are not the most friendly for Georgians. So do you know the minimum or average wage that a hotel worker makes here in Georgia?
I don't have that information off the top of my head, although I do have great representatives from the Georgia Hotel and Lodging Association behind me that may be able to answer that question. However, this is not really a question of wages. It is more of a question of someone preempting what they should not be doing, which is not basing a wage by an hour anymore, but by doing it by a job.
No, I appreciate your thought on there, but for the folk that are going to be cleaning those hotels, they're thinking about wages, and Georgia's minimum wage is what is it, $5.25? So I just wanted to understand your thought pattern about that. So thank you for answering the question.
Thank you.
Okay, we've got a couple of people out in the audience that want to speak for the bill. Nathan Humphrey, come up, tell us who you're with.
Good afternoon, Mr. Chairman, members of the committee. Always a pleasure to speak with you. My name is Nathan Humphrey. I'm with the National Federation of Independent Business, and we have done surveys on issues such as this. And on this particular one, 82% of our members across Georgia said they were in favor of this legislation. It provides predictability and uniformity, and which is important for businesses. And I'll just close with last comment, and that is the labor market right now is very, very competitive, and mandates just limit, in some cases, businesses' abilities to be creative and think outside the box to try and take care of their employees specific to their industry, which is not a uniform one-size-fits-all box to put all industries into. So anything we can do to incentivize creativity for small businesses to attract and retain workers is a good thing.
Thank you very much. Daniel New with Georgia Restaurant.
Thank you, Chairman Werkheiser, members of the committee. My name is Daniel New. I'm the Director of Advocacy for the Georgia Restaurant Association. We are in strong support of this bill as it will bring parity and consistency across the state, as Nathan from NFIB mentioned earlier. And if you have any questions, I'm happy to take any.
Thank you very much.
Thank you.
Online, we've got Ray with the Georgia Budget.
Yes, thank you. Good morning, and thank you, Mr. Chairman, for the opportunity to provide testimony. My name is Ray Califani of the Georgia Budget and Policy Institute. We have a longstanding interest in supporting racially equitable economic opportunity, which we believe local governments can directly provide. As such, GBPI testifies today in opposition to SB 331 to instead offer an alternative line of reasoning to support localities' freedom to pursue livable, equitable pay standards to help maximize job quality, to boost pay for low-wage jobs, which are disproportionately held by Georgians of color, and address their unique economic and workforce needs. And more specifically, that's supporting local government freedoms to regulate work hours, scheduling, and output would avoid adding insult to injury to piece rate workers in Georgia, who frequently sacrifice their physical and mental health to meet inhumane employer productivity standards that often purposely make livable pay, let alone overtime pay, unreachable. Among other things, barring localities from regulating output would mean that they cannot ensure equitable overtime pay thresholds for workers who receive pay based on an often incomplete measure of their productivity, which could inadequately compensate them, if not for overtime pay. So, passage of this bill means that hotel workers, some of whom are paid based on the number of rooms they clean, may not be compensated for all of their other intermittent and necessary tasks they do, such as ensuring that COVID cleaning protocols are met, particularly in guest rooms left much more untidy than others, or for time delays and disruptions in managing job tasks due to waiting for guests who check out of their hotel rooms late, as I'm sure many of us have done at one time or two. SB 331 could weaken local government's ability to create fertile conditions to strengthen quality job creation and worker retention efforts, and be counterproductive to large and small business employers across several industries, who seek to hire and maintain staff to meet consumer demand in Georgia, which is currently ranked number 2 in the country in the job quit rate. It's not in our best interest to further handcuff local communities from protecting their local income, their low-income workforce, who already suffer from stagnant minimum wage standards that don't keep up with inflation or allow employees to better afford to work and live in high cost of living communities. And it also adds to existing harms that bar localities from setting prevailing wage standards that could encourage more high quality companies to bid for local government contracts. So I'll close, and holding a ranking as the #1 state to do business should be synonymous with ensuring that business interests don't take priority over job quality. And while statewide uniformity of law can be a virtue in some ways, it's quite common for businesses to adapt to unique local environments, as they do with local laws regarding traffic, business licenses, and construction zoning. And local pay standards should be no different, where They should be in the hands of local leaders to equitably address the unique needs, particularly when our state has not set a livable baseline of pay standards that all localities can follow. So, Mr. Chairman, I thank you for the time, and I will yield back.
Okay, I think you had a question from Chairman Carpenter.
How you doing today, sir?
How are you?
Good. I want to run a scenario by you. I have I don't really have a hotel, but the scenario, I have a hotel in Whitfield County and I have a hotel in Bartow County. And the rules in Bartow are completely different than the rules in Whitfield County for paying and overtime pay. Do you not see that as a challenge to small businesses to have to keep up with the 7 different layers of government throughout the state versus a uniform statewide policy?
Well, I mean, I know that, businesses certainly have to keep up with a lot of different standards in different localities, but, as I mentioned earlier, they were already doing that. They've already done that for quite some time. I get it that, this situation can be very complex, along with others. But it's something that the businesses have been able to adapt to for quite some time. And I think that, being that, this is something that deals with the livelihood for so many of whom have been essential workers that have carried us through this pandemic. I think that localities, the business should also continue to adapt to what different localities have to put in place to meet the needs of their workforce.
Thank you very much. I appreciate it. I'm just concerned that this would actually be a deterrent for small businesses to be able to operate. Big businesses will definitely figure it out. They have the manpower to do so, but small businesses in particular would suffer greatly from having to deal with the different levels of regulation statewide. So I appreciate you coming today.
Thank you, sir.
Been a lot of examples about the Hotel Association, so let's finish with Chris Hardman.
Well, thank you, Mr. Chairman, members of the committee. I'm Chris Hardman. I'm with the Georgia Hotel and Lodging Association. I first want to thank the author, the Chairman John Albers, for bringing this important piece of legislation forward. It does several things, but most importantly, it brings consistency in an inconsistent environment. It's no secret that the hotel industry and the hospitality industry was hit first. It was hit worst, and it will be the last to recover. Most forecasts show that it won't recover until 2024 or 2025, until we can get back to 2019 levels. And I believe this brings positive reinforcement to our employers as well as our employees alike, so that our employees don't feel threatened that they're going to lose hours because they're doing too much work in their hotels. To also answer Representative Carter's question, I believe it was online, in hotels in Georgia, the average wage is roughly $15.35, which is huge for service employees. And that was from a year ago. It continues to rise. Most forecasts show it's rising around 20%. I'll actually get the most recent report next month, and I'd be happy to share that with the committee as well. But thank you, Mr. Chairman. Happy to entertain any questions and ask for your support of this bill.
Thank you. I believe earlier, Chairman Carpenter, you were ready for a motion.
Yes. Move to pass.
All right, all those in favor, say aye.
Aye.
All those opposed?
No.
Okay. We're going to do in person first. All those in favor, raise your hand. 4, 5, 6. All those online in favor, say your last name.
Bonner.
Hill.
Bonner and Hill. Anybody else?
Pruitt.
Okay. All those opposed in person, raise your hand. All those online, raise your hand. I'm sorry. Say your last name.
Carter.
Ark. Mudding.
All right. So the motion to pass Senate Bill 331 by Senate Committee Substitute LC 36510-5S Passes 9-5.
Thank
You're
you,
on the
Mr. Chairman.
rules. 9-5. All right. Floor Leader Meeks. Hey, I forgot, who's carrying the bill? Representative Ballinger, okay. Floor Leader Meeks, what you got?
Thank you, Mr. Chairman. Thank you for the opportunity to be with you today. Today we have House Bill 1331, LC 365081 EC is the draft from which we're working from today, Mr. Chairman. Mr. Chairman, members of the committee, thank you for the opportunity to appear before you today for House Bill 1331. 1331 is a piece of legislation that takes into consideration funding under the Workforce Innovation and Opportunity Act, which is a 4-title federal funding program that is worked out with agreements to the state. In previous years, Title I and Title II since 2012 have been moved both to TCSG for implementation and running those programs. Title II is the Adult Education and Family Literacy Act programs. Those are currently under TCSG. In 2015, the worker and youth programs were transferred to Department of Economic Development and then later to the TCSG for administering. Title IV funds of that program are strictly for the vocational rehabilitation services and are managed under the Georgia Vocational Rehabilitation Agency. So those funds will not move. So what this bill does, Mr. Chairman, is it moves Title III funding, the Wagner-Pizer funds from Department of Labor to TCSG for administration. And what that is, Mr. Chairman and members of the committee, is the employment services for unemployed individuals that are seeking employment. The TCSG has a great track record for Title I and Title II funds that they have been administering and exceeding the national average, and quite honestly, exceeding their goals set as an agency with helping individuals to attain employment, get better training, and direct them to where the jobs are available. As we know, Mr. Chairman, TCSG across our state and the system does a tremendous job in training employees for employment and they know they're in communities. They know where the jobs are. They know who the employers are. So, Mr. Chairman, it makes great sense that we transfer these funds over to TCSG for administering the program. Currently, as I mentioned, they're already doing this. We're already administering the funds. Department of Labor and TCSG offices are co-located. With the transfer of these funds to TCSG, we will not reduce any services across the state in any way. The offices will remain open, and those that are not open currently will be open to have greater access and provide tools for the unemployed across our state to seek additional job opportunities in different careers with TCSG directing them and helping them achieve the training that they need for that job. So, Mr. Chairman, that is the bill. Happy to entertain any questions you might have.
Great explanation. We have Representative Kennard.
Thank you, Mr. Chair. Thank you for the bill, Chairman Meeks. So this bill would allow better access and deployment of WIOA funds to individuals?
Yes, sir. You know what you speak. Currently both DOL and TCSG are administering the fund or administering the program. So what would happen? It was better streamline the program so that everything is in one location. There's not confusion as to who needs to be there to help out the unemployed individuals seeking employment. It'll just better streamline the process. Yes, sir.
Thank you. I work for Inspire Outreach. We help homeless individuals get back on their feet, and WIOA is one of those tools that we use to get people into stability. So thank you for the bill.
Thanks, sir.
Okay, online, Representative Park.
Thank you, Chairman Werkheiser. Thank you, Floor Leader Meeks. One question I had just in reading through the bill, you did mention that the intent is to transfer funds from the insurance commissioner to TCSG. The bill does state that it would be transferred to the governor's designee. So is it implied that the current governor would be transferring these funds to TCSG, but say under a new governor, would that provide a new governor greater discretion as to where these funds go if taken away from the insurance commissioner?
The bill does indicate it's Department of Labor that the funds will be transferred from. The bill does read the governor's designee. That is correct.
Thank you.
Representative Carter.
Oh, thank you, Chairman. So that was, my question was kind of concerning the language in the bill, as you're stating TCSG. If they're currently cohabitating, how is it currently working? Is it effective now, the services with the funding currently under the commissioner in the Department of Labor?
I think there's some confusion from individuals who are seeking the services as to which office to go to. In some areas, you have TCSG offices that are administering the program. In other areas, you have Department of Labor offices doing that. In some areas, Department of Labor offices may not be fully open yet. TCSG is. So at the intent of the bill is to make sure that there's clarification for Georgia citizens who are seeking unemployment services, that they know exactly where to go, so they are both co-located in one area and receive that direction and training in one spot.
Oh, thank you for that. But it still doesn't address the governor's designee, and so how will the intent be ensured with the language that is currently in the bill? And I'm not sure if I read that this was the purpose. Because it seems, because the governor's designee is going to be appointee versus the commissioner of labor is elected and has more accountability to Georgians. So if you could help me understand why that language is in there, because I can't connect that.
My explanation would be that under the federal code, the funding goes to the Department of Labor, and the commissioner then directs that funding. So the way it would work is it would still go to the Department of Labor, and the commissioner would then transfer the money to the governor's designee, and per the amended budget, that funding would go to TCSG as dictated in the budget.
Okay, Representative Holly.
Thank you, Mr. Chairman. And thank you, Chairman Meeks, for bringing this. I just want to know if I have it correctly, because I remember last session being in this committee where the Senate brought us a kind of a similar bill with a kind of a chief labor officer. And I remember that the governor was his first veto, when it passed out of both chambers. Is this essentially, it's a workaround so that the money doesn't necessarily come directly, even though it comes out of the same pot, that it won't have necessarily the commissioner of labor to handle it. This will be instead someone that is that the governor selects. It's essentially.
Well, it'd be the commissioner of TCSG and working with Department of Labor to transfer that money over, being that TCSG has the best opportunity to administer the programs throughout the state in an effective way for Georgians who are needing these services. That it would streamline the process. It would still go through the Department of Labor, and all of this has to be worked out within the final agreement with the federal government.
Okay, thank you.
And my guess is the governor is not going to veto this one.
It is the governor's bill. Yes, sir.
Representative Kennard.
Yes, one more just statement. I'm all in favor of streamlining it to get it into the hands of our technical colleges, because in my case, Gwinnett Tech College has a 99% employment placement rate. So that's a very good use and a very good way to get it directly to the people. So thank you.
Thank you. Thank you for that, sir.
I think we've exhausted all the questions. I do not see anyone signed up. Is there anybody in the audience speak? At this point, I would entertain a motion. We have a motion to pass on
Second.
House Bill 1331 LC 365081-EC from Representative Kennard. Is there a second? Second, Mr. Cameron. All those in favor, say aye.
Aye.
All those opposed, say no. Thank you. You are on the rules.
Thank you, Mr. Chairman. Rules of
Online needs to vote.
Oh, I'm sorry. All those in favor online, say aye.
Aye.
Gotta get used to this. All those opposed, say no.
No.
Okay, thank you. It passes. You're on the rules. Bring it up and I'll sign it.
Thank you, Mr. Chairman and members of the committee.
Representative Beth Moore. Okay, all right, okay. The mic is all yours.
All right. Good morning, industry and labor. Appreciate y'all's time. And really appreciate the chairman allowing me to bring a hearing on this bill. So House Bill 1375 addresses both a political issue and a constitutional issue. And over the past couple of weeks, I've started to learn more and more about workers' comp. It is a very complicated area of law. So I commend every member of this committee for taking on this otherwise very complex and very important topic. Well, it has come to my attention that there is an area of the code that I find incredibly objectionable. And in my conversations with many of you on this committee, I think I get the sense that many of you agree. And by the way, Representative Carpenter, this is the bill I was trying to talk to you about yesterday. Just so you know, I tried to come and talk to each of you. So if I missed you, I apologize. There are a lot of people on this committee. So what this bill does is it addresses a provision in the law dealing with the termination of workers' comp benefits that are payable to a surviving spouse when a spouse dies on the job. There are two events that can trigger the termination of those benefits, and can deny a surviving spouse the settlements payable on a workers' comp claim. And the two events that can occur that would terminate those benefits, number one is upon the remarriage of the surviving spouse. To me, that's okay. That seems to follow family law protocol. When somebody may be receiving alimony, they get remarried, their alimony terminates. I get that. That's fine. But the second thing really amounts to if the surviving spouse starts dating again. And I find that highly objectionable. So if you don't mind, I'll just walk you through what the current language of the bill is and what I am seeking to eliminate. There is no new language that I'm seeking to add, but just to take away some of this language that I think is maybe a little outdated. Starting with, line 11, this is where it's talking about the dependency of a spouse upon a deceased employee and these events that would trigger the termination of those benefits. You can see remarriage right there on line 12. We're going to keep that, right? If the surviving spouse gets remarried, that's cause for termination of the benefits. But you can see the second event is listed right there too. It says, or cohabitation in a meretricious relationship. Meretricious relationship. All right. What is that? All right. Well, the statute goes on to define what they mean by that. And it says, for this purpose, cohabitation in a meretricious relationship shall be, and here's where it defines it, a relationship in which persons of the opposite sex live together continuously and openly in a relationship similar or akin to marriage, which relationship includes either sexual intercourse or the sharing of living expenses. Committee members, since when do we allow the government to intrude upon our sex lives? What this means is that, well, first of all, I want to say, for those of us who have been married before, is there anything that is similar or akin to marriage? I would say no. Marriage is unique. Marriage is special. We don't recognize common law in the state of Georgia anymore. So I would argue nothing is similar or akin to marriage. Marriage creates a legally binding contract recognized by the state that requires spouses to be financially responsible for each other. The same is not true between boyfriends and girlfriends. We're boyfriends and boyfriends. We're girlfriends and girlfriends. So that is the first thing I will point out. What this statute means in practical terms, there was a question by one of the members of the committee as we were talking about this bill actually it was another member of our chamber who sits in front of me. He could not believe, first of all, that this is actually on the books in Georgia. But then he said, do insurance companies really invoke this statute when trying to deny claims? Oh boy, we got some people waiting to testify that absolutely they do. Absolutely they do. They will send private investigators to a widow's home to monitor the cars that go in and out, to see if any of those cars stay overnight. And they will put a poor widow on the stand who maybe just lost her husband at work. She's trying to get her life together. She's trying to move on. She's trying to heal. And they will interrogate her about who she is having sex with. And if they're able to reveal that she is, they will use that as the basis to deny her claim. Because apparently boyfriends and girlfriends are financially responsible for each other. That's what they're going to claim. Is that the purpose of this is to, is that the spouse, the surviving spouse is, the widow is no longer financially dependent upon the workers' comp benefits. That is not true. There is no legal regime that requires a boyfriend or girlfriend to be responsible for the person that they're dating. And I just think it is an absolutely sickening practice that attorneys can put a mourning widow on a stand and interrogate her about the most personal thing that we can do, as though that has anything to do with workers' comp. I also pointed out that there's a constitutional issue here. You know, the Obergefell decision made it the law of the land that gay marriage is legal, including right here in the state of Georgia. And regardless of your personal decisions on that, that is the law. And this statute, in my opinion, is on its face unconstitutional because it defines the relationship, the meretricious relationship in this case, as only one being between an opposite sex couple. So really, guys, this statute manages to be both homophobic and discriminatory against straight people. Because only someone involved in a straight relationship would be denied these benefits. So we've got some other folks that want to speak to the bill, but I'm happy to pause and take any questions from the committee.
Well, you've certainly got some. First of all, I want to, since I get to do this, make a comment or two. And I'm going to tell you, just like all other, because people are wondering what action we're going to take. We are going to send this to the advisory council, and I talked to you about that, so wouldn't it be a surprise? And it goes back to your very first comment when you sat down. You said that you don't know how this committee works through the intricacies of workers' comp because it gets complicated. And so that's why we do have an advisory council that has worked very well since 1992. It's made up of 110 members of subject matter experts. I've spoken to them about this already, and they agree there's some problems here. But also, I'm surprised every year of what's in all those code laws, but you get the award for finding this one. So I'm going to try to take these in orders. Representative Kirby.
Thank you, Mr. Chairman, and thank you, Representative, for bringing this bill. And like Chairman, as much as I've been through the comp laws, this one surprised me. I had not run across this little section. Just wanted to add something to it, meretricious. I did have to look that one word up. And actually, instead of us, whoever wrote this, when they wrote it, instead of redefining it, if they would have used Merriam-Webster, I think it would have been more appropriate where it says apparently attractive, but having in reality no value or integrity. That's how Merriam-Webster defines meretricious. And that's what they're talking about, something with no value or integrity at all here. So thank you.
We rest our case then, yes.
Representative Holly.
Thank you, Mr. Chairman. So you rest your case. I think probably the insurance would probably say that there was too many cases that were resting. So these parties, in terms of, I'm trying to really even get a sense about how would the claim be denied if in 2022 is a swipe left like a keeping, a swipe right like is, because there's Tinder apps. How do you prove a relationship? In a sense, like I just keep thinking maybe there's somebody it's like a Pink Panther thing, like with a trench coat, and you're trying to find are you sleeping? Are they sleeping together on the same couch? Are you laying on her lap? Or at one point do you signify what's proper courting? Right, that's what it is. It's that just couples don't court anymore. So thank you, Senator. Thank you, Representative, for bringing this. And but this needs to go on Saturday Night Live. But thank you.
Well, and if you don't mind, Representative Holly, thank you for your question. Who knows, how they determine this, but it is laid out in the statute that they determine a meretricious relationship to be one including sexual intercourse, which involves, a deep dive into somebody's bedroom, right? On the one hand, the government, because we passed this law, and on the other hand, defense attorneys for the insurance companies. And then it talks about the sharing of living expenses. What does that mean?
What is that? Yeah.
What does that mean? Like if my boyfriend lets me use his Netflix account, does that count? I mean, it's crazy, but I will add one point I forgot to make earlier, just broadly, is that the inverse of this situation is also not true in the sense that if you have let's say a boyfriend girlfriend couple and the boyfriend dies on the job, the girlfriend does not receive the workers' comp benefits. So this reads to me like the insurance companies are trying to have their cake and eat it too.
Yeah, they went on both sides. Yeah.
Yeah.
And Representative Hall, you have to wait till next year to call our senator.
Make sure that on my future dates that we go judge.
All right. 13 was next. Which was that? Kennard or Barton?
I didn't know my button was hit, but
Oh, go
since you
ahead.
called on me,
Okay.
as you know, I don't usually like to speak, but
We're
and
gonna
I
give
do
you
have to go
exception
to
on this
another
one.
committee meeting. But I did wanted to say, in case anybody was wondering, that bill did not have my LC on it.
Well, I think it was written way before Netflix was even invented. All right, is that Representative Carter, Chairman Carpenter?
Thank you, Chairman. So Beth, I would, Representative Moore, I apologize. I would probably say that if this particular male or female is in a relationship as such, maybe the mourning period has already been over. So that would be my only objection to it. But I support the cause and appreciate you bringing it.
Well, thank you. And, mourning is as much a personal issue, I think, as our choices when it comes to things like sexual intercourse. And people mourn differently and they heal differently. One of the objections to this bill from somebody I talked to is like, oh, well, that's in there so that people don't just delay getting married. And I'm like, since when does the government tell people when they have to get married? I mean, that's a very personal decision. And sometimes cohabitation, in the sense that we might think of it, is something that we do on the road to remarriage. We're talking about a widow, somebody who just lost somebody they thought they were going to spend the rest of their life with, and they lost them a little early. So let's allow widows to go through the mourning process, the healing process, to develop relationships. And also there's something to be said about how this bill also prohibits widows from taking on roommates. I think we'll hear, I don't want to preempt some of the testimony that might occur in this space, but imagine that one of your family members lives on a large piece of property, a husband and wife, and the husband dies unexpectedly on the job. Now you've got a widow, the surviving wife, who has to take care of that very large property. So maybe she needs to bring on a roommate, a farmhand, somebody to take care of the property. Well, there are cases where in that situation, a little old lady who lost her husband is being interrogated as to whether or not she's sleeping with the farm boy. That's also what we're trying to prevent. It's
Cool
just
down.
the unnecessary interrogation of attorneys into our personal lives.
All right, one last, two questions. McLean, Representative?
Thank you, Mr. Chairman. And I guess, Representative Moore, I guess, we spent about 30 minutes on redacting 4 lines. And I do hope Mr. Chairman, the advisory board takes this up because it's definitely got to be outdated. I was glad to hear our Sean Marisa, her LC number is not attached to it. So, and I guess we don't know when this was written. But I do know the advisor I know they would take it under consideration because I definitely know that this is not right. So I just want to thank you very much for finding it. And I do hope that, Mr. Chairman, the advisory board, maybe they can start going through some of the workers' comp law and picking up some of this and doing some cleanup. But maybe that might be a little bit too much work. But sometimes it's always good to do some cleanup. Again, thank you very much for the comment.
Thank you, Representative McLean. It makes me think about your motto, which is right is right, is wrong, wrong is wrong. And I think we know what the case is here, that it would be the right thing to do to pass this, and the current statute is wrong.
And maybe had it been sent to code revision, it might have went through quicker without the extra layer. All right, Representative Park online.
Thank you, Chairman Werkheiser. Representative Moore, just wanted to say thank you for the bill and an excellent presentation and explanation of the unnecessary burden this places, particularly on those who may be mourning. I do again hope, I just want to reiterate Representative McLean's comments of, I do hope the advisory committee favorably takes this matter into consideration and we see some progress on this matter come next year. Thank you.
Thank you.
Okay, you've got a couple of people who have signed up. In the room is David Merkowitz. Come on up.
My name's David Moskowitz. I'm a private practicing workers' comp attorney. And I have to tell you, I know many of you, and I really do not like having to come here and address this body. It would be like the last thing I want to do. I think Representative Moore has kind of summed up just about everything I could possibly say. But I've had this case on both ends. I had the 70-year-old woman whose husband died and lived on 50 acres and had a farm boy take care of her place. And they did surveillance. And it was horrible, the hearing. I had to get up there and ask this poor woman if she had consummated the relationship with the person that she was having lived there for her own protection. And she lost her benefits and went 2 years without them. But beside the point, I think what we need to emphasize here are 2 things. Number one, these workers' comp benefits to these dependents, the spouses, the decedent's spouses, is based on dependency. That's the sole standard in workers' comp, that they're called dependency benefits. And the problem here is I've had the other case on the front end where I had an individual who fell 50 feet and died, and his girlfriend for many years could not get the benefits under this meretricious relationship that they had. And she was as dependent as anybody, but it didn't fly here. But on the back end, my client lost their benefits for not being dependent on someone. So the point I'm making is this is a horrible equal protection argument under the 14th Amendment and due process of the U.S. Constitution. I litigated it to no end. The Supreme Court of Georgia did not take it. I lost all the way up because the courts are bound in many of these by what the law we have. And here's another thing that I really do want to add, and this is no slight to the advisory council, but I was on the advisory council years ago when this went through. If I'm not mistaken, the legislative date on this is like 1994. So I know it'll go back and hopefully it'll be fixed, but I think that this one's pretty clear and really should go forward now. It's just a mix up and a bad piece of legislation that existed and how it got through. 20 something years ago, anything can happen. But that's just my belief on it. I think it's been on the books long enough and I think we could fix it now, would be my hope, but it's your decision ultimately.
All right. Well, I'm just trying to be consistent. And thank you, David, as always, for your involvement in this committee. On Zoom, we have Jonathan Smith.
Yes. Good morning, Mr. Chairman and representatives. Thank you for your time. Thank you for bringing up this bill, Representative Moore. I'm happy to speak today to it. My name is Jonathan Smith, and like Mr. Moskowitz, I represent injured workers in the state of Georgia. I'm a partner with Morrison and Hughes out of Marietta, Georgia. Yeah, I was asked to speak on this bill because this is something that I'm encountering routinely. I realize that this committee is of the perspective that this is some deep dive into workers' compensation that existed for 30 or 50 years. But so far this year, I've been involved in 2 separate cases where this has become a tangible legal issue for purposes of argument. Unlike Mr. Moskowitz, I haven't had one run all the way to the Supreme Court, but that opportunity exists. There are 2 points I want to make on this. One is how it plays out in actual practice. And the second is the sort of idea of correcting this legal standard at, better line with most areas of law. I am presently pausing a mediation for a widow seeking death benefits. She was married for 25 years. Her husband passed, in our opinion, related to her work or his work accident. She has been served discovery, deposed, and then asked follow-up questions about the nature of her relationships. Unlike the woman on the 50-acre farm, she's gone years without payment of benefits. So, if they assigned a personally or private investigator, they'd find her living in her car. We're looking at a circumstance where Georgia widows, and it is widows because women are 10 times more likely to be widowed than men are due to work accidents. Georgia's widows are losing these benefits and waiting for these benefits under the guise of a gray area or legal argument. And then they're being investigated aggressively to support the idea of the non-extension of workplace benefits. Moving forward from just in practice, the encounters that I've had this year, when we look at marriage as the standard, it's a bright rule. It's an agreed upon governmental sanctioning of a relationship. We see it extended in areas of tax, insurance, payment of benefits, etc. The sanctity of formal marriage is held in high regard throughout our laws, and it makes sense to extend that to this workers' compensation setting. Thank you so much for your time.
Thank you. That's very good testimony. I don't see any other questions. Anybody out there wishing to speak? Okay, with that, we're adjourned. Thank you.
Thank you.
Hey, have learned a little bit about Robert's rules over the years. So since I adjourned us, I am now calling us back this meeting to order. We'll let Mr. Barton's prayer stand over both. So Michael, sorry about that. That's Representative Smith, totally my fault. And you were out 2 days ago, and then yesterday I could not find you on the floor. I have a substitute. I don't even know if you've seen it. But tell us about your bill, and then we'll talk about the substitute.
Absolutely. Thank you, Mr. Chairman and members of the committee. Thank you guys for allowing me to be here. I think this bill that I have before you all is a pretty simple bill. What it will do, it will require that a place of business that hires minors to have a mandated reporter for someone to be able to report to. Once again, this is a pretty simple bill. And the reason for it is because I used to be a school teacher. As a school teacher, mandated reporters, I feel saved the lives of many kids. And I've seen that happen firsthand. And as a former minor employee, in fact, I used to work at Chick-fil-A when I was 15 years old. There's lots of things that happens, at a job. You also build a rapport with supervisors and other people that are there. And perhaps maybe information could be disclosed that can end up saving someone's life. And I believe that the mandated reporter system or procedures has worked well in our school systems. And I believe it could also work well in the place of employment. And with that being said, Mr. Chairman, I'll stand for any questions. And I do have the substitute. And excuse me for feeling rushed. I just found out that the meeting was changed.
Okay, and let me tell you where the substitute came from. Almost every bill that has to do with HR, Vice Chair Kirby is my sifting device. And so he reads these bills very thoroughly and always has some great suggestions. So I'm going to turn it over to him to let you know where the sub came from.
Absolutely. Thank you, Mr. Chairman. And thank you.
Sorry. But we were very happy working with the representative on this bill. And as an HR professional, I certainly, even though we don't in a manufacturing plant have the opportunity to hire too many minors because of some other rules that we have to deal with, forklifts and everything. An HR professional should be fully equipped to handle this, be trained. And I think it's a good thing if they're witnessing something or being told. If my supervisor, if I did have children and they brought this to my attention, I should have the responsibility to make sure it's reported. So I think that's the right place for it to be in the HR professional's hands to report that up. We can go into too many stories where somebody down the line didn't know what to do or didn't do it right, and it caused more problems. So get it to the professionals and give them that mandatory reporting. And I think this substitute bill clearly does what the representative wants it to do. And I think it's a good bill. And if you want to at the appropriate time, I'd certainly make a motion on it.
Okay. Any questions? Representative McLean.
Thank you, Mr. Chairman, and thank you, Representative Kirby, for this. I guess my only question is, so why do we come up with 5 employees? Was it just is that standard?
Representative Smith, I assume you had conversations with Ledge Council, so you might can tell us about that.
No, absolutely. When we're looking at businesses, there are very small businesses or family-owned businesses. We don't necessarily want to make this cumbersome for really small businesses or mom and pop shops that have less than 5 employees. And that was the rationale behind it all. I believe that if you have more than 5 employees, and that also increases the interactions that people would have with adults with the more employees that you have. And that was my rationale for capping it at 5.
Thank you, Mr. Chairman.
Anybody else? Any Representative Park?
Thank you, Chairman Werkheiser. Representative Smith, thank you for this bill. I was wondering, and Chairman Werkheiser, maybe this is something that one of our association groups could help provide, but how many employers in the state of Georgia with more than 5 employees employ minors? Because this does come across, or I read this as a very common sense way in which we can protect minors who may be working at our businesses.
I'm going to let Representative Kirby answer that.
Gee, I can't give you the number, Representative Park, but I think we could sit here and brainstorm a list of industries, starting with fast food industries and a lot of things that a lot of those jobs that we all had even in high school or high school students work today and go through that. I mean, you get into manufacturing and things like that, you're not going to have a lot of minors out on the manufacturing floor, but there are a lot of internship programs now with different administrative jobs that are available for these high school kids. So when we're dealing with minor children, it's going to cover just about every industry in the state in some way if they choose to participate in hiring minors, whether an internship or program or not.
Thank you.
All right, seeing no other questions. Anybody want to speak out there? at this point, we could take a motion. Representative Kirby.
On this committee substitute to HB 849 LC 365217S.
First, motion by Representative Kirby, second by Representative McLean. All those in favor say aye.
Aye.
All those online,
Aye.
all those opposed in the room. All those opposed online. Congratulations, the motion carries. You're on the rules. You can bring me
Thank you,
your
Mr.
form.
Chairman. Thank you, Chairman Kirby. Thank you.
Thank you.
Thank you, members of the committee.
We are adjourned again. Yeah. All right. Don't get mileage for the second one.
Okay, won't get no mileage.